Good afternoon, everybody. You're all very welcome along, joining us this afternoon to our latest in our legal services webinars with Milselig. As I say, you're all very welcome. This session will be recorded, and we will be sharing both the recording and the slides after the event. But should you have any questions as we go through the event, then please use either the Q&A function or the chat function, and I'll take those questions to our presenters before we finish off today's session. Today's session is on directors' duties and corporate governance, how to protect yourself and your business. For directors in manufacturing, this topic is increasingly important. Expectations around governance and compliance are rising, and getting the fundamentals right helps protect you personally as well as the business. Today's session is designed to give you practical advice, and will cover directors' duties, company's house compliance changes, including any identity verification, insolvency considerations, disqualification risks, and governance best practice. We're delighted that we partner on this legal series of webinars with Milselig, who've been supporters of Manufacturing NI for a number of years now. And Milselig will deliver the session, and we're joined today by two of their corporate team. First, we'll hear from Lindsay McSherry. Lindsay is a senior associate in the corporate team. Lindsay specialises in advising directors and shareholders on corporate governance and compliance, including company formations, restructures, and share and asset transactions, and with particular expertise supporting manufacturing and commercial businesses. Alongside Lindsay, we have Emma McCluskey, who's also a senior associate in the corporate team at Milselig. Emma advises directors on governance and directors' duties, particularly in complex commercial transactions, and is known for helping businesses navigate asset acquisitions, corporate restructures, share transactions, and the negotiation of commercial and corporate agreements. Lindsay, I'm going to hand over to yourself, but just to remind everybody, please do pop questions into our Q&A function or into our chat. And as the presentation finishes, we'll come back to you, both yourself and to Emma, with those questions. But we'll hand over to you for now, and we'll speak to you in a few minutes.
Thank you very much, Stephen. I'm going to kick us off today just by discussing the director's duties. I'll then move on and talk a little bit about disqualification and some of the common issues that are faced by directors. And then lastly, it'll be a very light touch on insolvency. So basically, there are 7 core statutory duties. These are set out in sections 171 to 177 of the Companies Act. We will go through each of these in turn, but before we do, I think it's worth noting that first, these duties are personal to the director. They can't be delegated away. Secondly, they're judged by a combination of both objective and subjective standards, meaning what a reasonably diligent person would do, taking into account the director's actual knowledge and expertise. These duties apply to all directors, so that's whether you're an executive, a non-executive, a de facto director, or a shadow director. And importantly, the duties are owed to the company itself. They are not owed directly to shareholders, employees, or any other stakeholders. So our first duty is the duty for a director to act within his or her powers. This requires a director to act in accordance with the company's constitution and only exercise their powers for the purposes for which they were given. The company's constitution includes its articles of association, any resolutions passed by the board, and any agreements of a constitutional nature. So that would be your shareholder agreements or your JV agreements. A common risk we would see here is that whilst directors might technically have the power to do something, they might use that power for an improper purpose. So say, for example, you're issuing shares not with the aim of raising capital, but instead you're seeking to dilute the shareholder. That would be an improper use of your powers. So in practice, this means that directors really do need to understand the company's article of associations, those constitutional documents, to know what their powers are, where their powers lie, and what they are able to do. Our next duty is the duty to promote the success of the company. So this is often described as the central duty under the Companies Act. It requires a director to act in a way that they consider in good faith would be most likely to promote the success of the company for the benefit of its members as a whole. So this includes taking account of the likely consequences of any decisions in the long term. the interests of the company's employees, the need to foster the company's business relationships with its suppliers and customers, the impact of the company's operations on the community and the wider environment, the desirability of the company maintaining a reputation for high standards of business conduct, and the need to act fairly between members of the company. In practice, this is where board minutes become really important. Minutes don't need to be lengthy, but they do need to show that all the relevant factors were considered by the directors and were discussed before entering and making any decisions. Next, we have our duty to exercise independent judgment. This is where directors must exercise independent judgment and make their own decisions. For example, a director can't simply defer to the wishes of a shareholder or another director or another person, whoever that may be, without bringing their own independent judgment to bear on the issue. They also can't agree with a third party, such as any appointing shareholder, to vote at board meetings in a certain way, even if that vote wouldn't otherwise have breached their duty. In other words, basically, directors can't just act as a rubber stamp. They need to make their own decisions and use their own judgment. Now, this doesn't prevent or restrict directors from acting in accordance with the company's constitution, nor does it restrict them from taking advice on any matters. They absolutely can, but any reliance on this should be reasonable, and any advice that they are taking, they really should understand it. Moving on then, we have our duty of exercising reasonable care, skill and diligence. So this is where directors must exercise the same care, skill and diligence that would be exercised by a reasonably diligent person with both the general knowledge, skill and experience that may reasonably be expected of a person carrying out the functions carried on by a director in relation to the company. That's our objective test. And then we have the general knowledge, skill and experience that the director actually has. So that's the subjective test. This duty, it's not looking for perfection, but it is looking for reasonable care. Some practical examples would include reading your board papers before any board meeting, asking questions if you don't understand something, monitoring your company's financial performance, and then seeking advice when it's needed. Our next duty is to avoid conflicts of interest. So this is where a director must avoid conflicts of interest whereby a duty to avoid conflicts of interest whereby a director must avoid a situation in which they have or could have an interest that conflicts or may conflict with the interests of the company. So this applies in particular to the exploitation of any property, information, or any opportunity, regardless of whether the company could take advantage of such opportunity. Conflicts aren't automatically prohibited, but they have to be authorised and managed properly by the board. We then have the duty not to accept benefits from third parties. So Section 176 of the Companies Act codifies the rule prohibiting the exploitation of the position of a director for personal benefit without full disclosure of all material circumstances. In short, directors can't accept a benefit from a third party given just because they are director and it's being given as a thank you for something that they did or didn't do. That then leads us on to our final statutory duty, which is the duty to declare interests in proposed or existing transactions or arrangements with the company. So if a director has any interest, directly or indirectly, in a transaction or arrangement with a company, they must declare the nature and extent of that interest to the other directors. In the case of a proposed transaction, you need to do this before this transaction is entered into, or in the case of an existing one, you should notify as soon as it's reasonably practicable. In practice, this is where a properly convened board meeting will always begin with the chair setting out the business to be discussed at the meeting, and then those directors present should therefore declare any interest that they have. Transparency is key here. Failure to declare an interest is one of the most common technical breaches by directors. It's often accidental, but it is a breach. Therefore, full and frank disclosure of any interest is really encouraged, and anything other than that really won't be compliant with this section of the Companies Act. Outside of the statutory obligations then, there are other obligations imposed on directors. Some of these include confidentiality. So a director owes a duty of confidentiality to his or her company and must use or disclose the company's confidential information only for the benefit of the company. Directors are responsible for ensuring that the company complies with its obligations relating to health, safety, and welfare at work of its workers under health and safety legislation. And then there are all other obligations that arise under environmental legislation and anti-corruption legislation. I'm now going to take a very quick look at director disqualification and some of the common issues that directors face. So the whole idea of director disqualification is that it's designed to protect the public from individuals whose conduct shows that they're unfit to manage company. Disqualification can last up to 15 years. During that time, a person can't act as a director, be involved in company management, or act through any nominee or attempt to act behind the scenes of a company. Common triggers of disqualification include persistent breaches of Companies House obligations, trading while insolvent, a failure to keep proper records, and serious breaches of duty. Being disqualified as a director is not a criminal offence in and of itself, but breaching a disqualification order is a criminal offence. So we'll have a run through the issues that directors commonly face now. The first of which, and I know I've already touched on this, but it's conflicts of interest. A conflict of interest occurs when an officer or another controlling member of a company has other financial interests that directly conflict with the objectives of the company. So when conflicts of interest are present, these really do deteriorate the trust of shareholders and the other stakeholders while making the company vulnerable to litigation. Our next issue is corporate oversight issues. So directors need to have a substantial oversight of the company's procedures and practices. Oversight in and of itself is quite a broad term, but essentially it encompasses the executive staff reporting to the board and the board's awareness of the daily operations of the company and the ways in which the company's objectives are being achieved. The idea behind this is that the board protects the interests of the shareholders and acts as a check and balance system against executive staff. Following on from any oversight issues will therefore be accountability issues. So each level and division of a company should report and be accountable to another as a system of that checks and balances I've just mentioned. Above all else, the actions of each level of the company is accountable to the shareholders and other stakeholders. So without accountability, one division of the company might endanger the success of the entire company or cause other stockholders to lose their desire to continue any investment or interest with the company. We next have shadow directors and de facto directors. So as we know and we've worked through, those appointed as company directors have certain duties to abide by, and they can be held liable for the conduct in the day-to-day running of the business. What fewer people may not appreciate, though, is that there are individuals who are involved in a company's business that can, in certain circumstances, be found to be liable for breach of director's duties without being formally appointed as a statutory director. So these individuals are what we know as shadow directors or de facto directors. And one of our big issues that we see coming up is accounts violations. So where a company's in financial difficulties, a director should seek independent advice as soon as possible if they're to avoid any potential personal liability under insolvency legislation. The potential risks for a director here are complex and include the risk of being disqualified. So this is where that duty to exercise due care, skill and diligence really does come into effect. This duty is really easy to demonstrate when a company is prosperous and it's financially sound, but when difficult decisions are needed to ensure a company's financial standing, those decisions can become a lot more difficult, which leads us into insolvency considerations. One of the key issues for a director of a company which is insolvent or approaching insolvency is the modification of the general duty to promote the success of the company. So when a company is solvent, we know that the director's duties are owed for the company of the benefit of its shareholders as a whole. However, when a company is insolvent or nearing insolvency, the law actually requires directors to increasingly consider the interests of directors. Now, this doesn't mean like it's a flip overnight. It's really more of a sliding scale. The warning signs of insolvency include cash flow pressure, inability of the company to meet its debts as they fall due, a reliance on creditor forbearance. Once insolvency is likely, directors need to be really cautious about continuing to trade, paying some creditors in preference to others, and taking on new liabilities. When it comes to insolvency, then one of our biggest risks is wrongful trading. So a director can be ordered by a court to contribute towards a general pool of assets, which are then used and made available to a company's creditors. This can be done where a director knew or ought to have included that there was no reasonable prospect of the company avoiding insolvent liquidation or administration, where he or she continues to allow the company to trade after they knew this or ought to have concluded that they weren't avoiding insolvency, and where they did not take every step that they ought to have taken from that time to minimise the potential loss to the creditors. Really importantly here, a director doesn't have to be dishonest to be liable for wrongful trading. And you can't avoid responsibility just by resigning from your position as a director when difficulties arise. That leads me to my final point. That was very much a whistle stop tour there, but I'm going to do a very light touch on practical insolvency safeguards. I think our colleagues Richard and Catherine is running the next manufacturing and I seminar on insolvency, and they'll speak in a lot more detail about this. But at a very high level, this is a really difficult and thorny area for any director to navigate. The key protective and proactive steps for directors include seeking professional insolvency advice as early as possible, keeping accurate financial information, holding frequent board meetings, discussing with the board any issues that are arising, and then following on from that, carefully documenting your decisions and carefully documenting what went on in those board meetings. So courts and insolvency practitioners will look really closely at what directors did and when they did it. And with that comes the fact silence and inaction is rarely defensible. That's the final point for me. So I'm going to hand over to Emma, who is going to talk to you about best practice compliance and recent Companies House changes.
And thank you, Lindsay. So corporate governance is fundamental to how a company is directed, and it controls the forms and the legal and practical framework with which directors must then operate within. So under UK law, directors are subject to statutory duties, which have just been helpfully covered off by Lindsay, as well as duties that arise under companies' constitutional and contractual documents. So a clear and informed approach to governance is therefore essential to ensure compliance, effective decision-making, and protection of both the company and its directors. So key governance documents, including articles of association, shareholders agreements, director service agreements, define the allocation of powers within the company. They regulate decision-making at board and shareholder level and set out the rights, obligations, and protections that are available to directors. So a thorough understanding of these documents enables directors to act within their authority, avoids conflicts, manages risk, and makes decisions that are legally robust and aligned with the company's long-term business interests. Effective governance also provides clarity during periods of change or challenge. So when a company is growing or seeking investment, restructuring, or even during shareholder disputes, and it reduces the likelihood of personal liability, regulatory breaches, or costly disputes. So let's look at the typical documents then that we tend to see that evidence strong corporate governance. So the Articles of Association then. The Articles of Association are the company's primary constitutional document and form the foundation of a company's corporate governance. For directors, articles define the scope of their authority and the rules within which they must exercise their powers. And while many UK companies adopt the model Articles of Association and Incorporation, often with minimal amendment, the articles are not a one-size-fits-all document, and they should reflect the company's ownership structure, management model, funding arrangements, and long-term strategy. Poorly drafted or outdated articles can create uncertainty, restrict effective decision-making, or expose directors and the companies to unnecessary risk. The articles are central to determining how the company is managed and controlled. You'll find that articles will typically regulate the composition and appointment of the board of directors, the director's power to manage the business, quorum and voting requirements at board meetings, delegation to committees or other individual directors, and matters that will require shareholder approval. Directors must then act within the powers conferred on them by the articles. Decisions taken outside those powers may be invalid and can result in personal liability. Clear and well-structured articles give directors confidence as to what they can do and how decisions should be properly documented. In 2022, the UK case of Hasme versus Lorimer Wing looked at the age-old clash between the model articles and proved really why they can't overly be relied on. So Model Article 7.2 states that if A, a company only has one director, and B, no provision of the articles requires it to have more than one director, the general rule does not apply, and the director may make decisions without any regard to any of the provisions of articles relating to directors' decision-making, which clashes with Model Article 11.2 that states the quorum for directors' meetings may be fixed from time to time by a decision of the directors, but it must never be less than 2, and unless otherwise fixed, it is 2. The decision by the court in this case ruled that a company governed by model articles of association required a minimum of 2 directors for a decision of the board to be legally valid. And often you see that companies that do have model articles adopted only have a sole director. So it could be argued then that any decisions that they make or enforce could potentially be considered invalid. So we always suggest that directors make the proactive decision to amend the articles of association and adopt bespoke articles that apply to the company. And that way you'll avoid any uncertainty around the decision of a director being valid. The articles govern the company's share structure and the rights attaching to shares, including voting rights, dividend entitlements, and rights on a sale or winding up. They also typically contain provisions relating to the issue and transfer of shares, preemption rights, compulsory transfers, and drag and tag provisions. These provisions are critical during investment rounds, management incentive arrangements, exits, or individual shareholder exits, and directors must ensure that share issues and transfers are carried out in accordance with the articles, as failure to do so can invalidate transactions and expose the company to legal challenge. The articles commonly include provisions relating to directors' indemnities, limitations in liability, and directors' insurance. These protections are of direct personal importance to directors. They are robust and legally compliant and can provide meaningful protection against claims arising from the proper or improper performance of directors' duties, whereas inadequate or outdated provisions in articles may leave directors feeling unnecessarily exposed. As a company grows, raises capital, or changes its ownership or management structure, its governance needs to evolve. And that's where articles that were appropriate in incorporation might become restrictive or unfit for purpose. Directors have a responsibility to keep the articles under review and to recommend amendments where necessary to support the company's development and strategic objectives. For those reasons, the articles should be regarded as a living governance tool that deserves careful consideration and regular review by the board. We're going to look at shareholders' agreements next. So if you pop on the next slide, please. So we've talked a lot today about directors' statutory duties under the Companies Act, duties that are personal, enforceable, and owed to the company itself. But what we want to look at now is something that isn't technically a statutory requirement, but in practice is hugely important for directors, and that's the shareholders' agreement. So shareholders' agreements are often thought as documents that matter only to the shareholders, but in reality, and from a director's perspective, a well-drafted shareholders' agreement can be one of the most effective tools for reducing risk, avoiding disputes, and helping directors comply with their statutory duties. So what we'll look at is why a shareholders agreement is not just beneficial, but in many cases essential. So a shareholders agreement, pop around to the next slide there, Lindsay, please. A shareholders agreement is a private contractual agreement between the shareholders of a company and the company itself. It sits alongside the company's articles, but it differs in 2 key ways. Firstly, it's private, so it's not publicly filed at Companies House the way that your articles or any amendment to the articles are. And second, it allows a much more detailed and bespoke regulation of how the company is owned, controlled, and managed. Although directors are not always party to a shareholders agreement, it is a direct and often significant impact on how directors can operate in practice. So why do shareholders agreements matter to directors? From a director's perspective, most personal risk doesn't arise from deliberately doing something wrong. It arises from unclear authority, conflicting shareholder expectations, being caught in the middle of disputes, or making decisions that look reasonable at the time, but are challenged later with the benefit of hindsight. A shareholders agreement helps reduce those risks by creating clarity and structure. Lindsay has already covered off the statutory duties in detail, and you'll remember that one of the core statutory duties is the duty to act within your powers as a director, to act in accordance with the company's constitution and for proper purposes. In many companies, the articles, and particularly the model articles, are quite high level and don't give much practical guidance. But a shareholders agreement typically will fill in that gap by setting out exactly what decisions the board can take on its own and what decisions require shareholder approval, often reserved to as reserved matters. And those are things and items that are sat down and carefully deliberated through about who can make the decision regarding them and whether that's a board approval or shareholder approval. For directors, this is hugely valuable because it gives directors a clear rule book of the specifics that they can do in their role. Directors are also required to promote the success of the company and having regard to a wide range of factors, which include long-term consequences and relationships with stakeholders. In practice, this duty can become difficult where shareholders have different priorities. Some shareholders might want short-term dividends, others might want reinvestment, long-term growth, and some may be planning an exit where others may not. A shareholders agreement can align those expectations by setting out the agreed strategic objectives, clarifying any dividend policies, dealing with funding obligations, and addressing exit scenarios. And for directors, this makes it much easier to demonstrate that decisions were taken in good faith, for proper purpose, and in accordance with an agreed framework. This can be critical if decisions are later challenged, that you can go back to the shareholders agreement and board meeting minutes and evidence that decisions were made properly. A shareholders agreement also manages shareholder conflicts and protects directors. Shareholder disputes are one of the most common sources of pressure on directors, and directors can often be placed in an impossible position where they're expected to keep the business running while shareholders are in conflict. Shareholders agreement therefore often include deadlock resolution mechanisms, escalation procedures, or buy-in or exit provisions. And from a director's point of view, that's invaluable because it reduces the risk of board paralysis, so the board being froze by the conflict and unable to act properly. It prevents directors from being forced to pick sides and supports the duty to act in the interest of the company as a whole rather than the individual shareholders. Shareholders agreements will also include who can appoint directors, what the board of directors will look like, and what the quorum and voting requirements are at board meetings. This is particularly important in companies that might have different levels to their governance. So, for example, if you have investor shareholders or founder directors that sit in your board and they might have different roles than your other statutory directors, or in joint venture arrangements. For directors, including clear wording on what the board of directors looks like and what their roles and rights are can provide certainty, stability, and clear accountability. In many companies, the absence of a shareholders agreement creates more risk for directors than its presence, and a well-drafted agreement gives directors clarity, protection, and confidence, allowing them to focus on running the business rather than managing uncertainty. Next slide then, Lindsay, please. On the theme that runs through all of the director duties in today's seminar is that directors are expected to act reasonably, responsibly, and in the best interest of the company. What directors are not expected to be is experts in every area of law, finance, tax, or corporate transactions. And that's where third-party professional advice comes in. Your solicitors, accountants, tax advisors, insolvency practitioners, and corporate finance advisors. Using professional advice is not just good practice. In many situations, it's a key part of how directors protect themselves and demonstrate that they have complied with their legal duties. So a director must exercise reasonable care, skill, and diligence and know their limits. The duty is judged partly by what a reasonably diligent director would do and partly by the director's own knowledge and experience. The law recognises that directors all have different skill sets, and a director doesn't need to be a lawyer, an accountant, or a corporate financier all at once. However, directors are expected to be able to recognise when an issue goes beyond their own expertise and when it's time to seek appropriate professional advice. And in fact, failing to take advice in complex or high-risk situations can itself be criticised as unreasonable conduct. Seeking third-party advice helps directors comply with several statutory duties at once. Legal advice helps ensure directors are acting within their powers and in accordance with the company's constitution. Financial and accounting advice helps directors understand the financial position of the company and make informed decisions. And strategic and corporate finance advice helps directors assess risk, value, and long-term consequences, all of which feed directly into the duty to promote the success of the company. In other words, professional advice supports better decision-making and makes it easier for directors to show they acted properly. There are certain situations where directors are very clearly expected to seek professional advice, and those include corporate transactions such as your acquisitions or disposals, significant financing arrangements such as entering loan agreements or securing company property, tax structuring and compliance, regulatory issues, shareholder disputes, and most importantly, financial distress or insolvency. In these areas, relying purely on commercial instinct or past experience is rarely enough, and courts and regulators expect directors to understand that these are specialist areas and to bring in specialist advice. One of the most important benefits of taking advice is actually what happens after the event. So when directors' decisions are scrutinised, whether by court, an insolvency practitioner, or a regulator, the question that they're often faced with is, what information did the director have at that time and how did they make their decision? Being able to show that appropriate advice was taken from suitably qualified professionals and that the advice was considered and discussed can be powerful evidence that the directors acted reasonably and in good faith. So while taking advice does not remove responsibility, it can significantly reduce personal risk. The importance of professional advice increases dramatically when the company is facing financial difficulty. As a company approaches insolvency, directors' exposure increases and their decisions are more likely to be examined closely. Directors are expected to monitor solvency carefully at all times, consider creditors' interests, avoid wrongful or fraudulent trading, and seeking early advice from accountants or insolvency professionals is often one of the clearest indicators that directors are acting responsibly. By contrast, delaying or avoiding advice is frequently criticised in insolvency investigations. As Lindsay touched on, our insolvency colleagues Richard and Catherine will be diving into this in their insolvency session next month. Many breaches of directors' duties are not deliberate. They can arise from technical non-compliance, missed filings, poor documentation, or misunderstanding complex rules. Professional advisors help directors navigate these issues and avoid problems before they arise, particularly given the increasing enforcement role of Companies House and the other regulators. It's also important to remember that professional advice is not just about legal protection. Good advisors bring an independent, objective perspective, experience from similar situations, and the ability to challenge assumptions. And that often leads to better strategic outcomes from the company, not just safer ones for the directors. So to summarise, in taking third-party professional advice, directors are not expected to know everything, but they are expected to know when to seek help. Using third-party professional advice supports compliance, reduces personal risk, improves governance, and leads to better decision-making. In short, seeking professional advice is not considered a weakness by directors, but a core part in being a responsible and effective director. Next slide then. I'm going to cover now our two very practical protections for directors in the UK. Directors' insurance, often referred to as director and officer insurance, and director service agreements. Again, neither of these removes any director's duties, but both are critically important to managing personal exposure. So if we start with directors' insurance, under UK law, directors can be personally liable for a wide range of claims, and these include breaching your duties, negligence, misstatements, regulatory investigations, and claims brought by shareholders or insolvency practitioners. D&O insurance is designed to cover legal defence costs, damages or settlements, and costs of regulatory investigations. So this is important because even if a director is found to be innocent and hasn't done anything wrong, the cost of defending a claim can be quite significant. So the Companies Act allows companies to indemnify directors and to take out insurance for them, but there are limits and your insurance can't cover fraud, dishonesty, or certain fines. But from a director's perspective, the key point is D&O insurance doesn't stop claims being brought, but it can prevent a claim from becoming financially ruinous. So directors should actively seek to check the cover of their policy and not assume that insurance automatically gives full protection. It's important to understand who's covered in your insurance, whether it includes former directors, what type of claims are included or excluded, whether defence costs are covered up front, and whether the level of cover is realistic. So simply put, D&O insurance is only effective if it is appropriate and kept under review. Alongside insurance, director service agreements are another key protection. A service agreement is entered into between the company employing the director and the director personally, and it sets out the terms on which the director is appointed, including their duties and responsibilities, remuneration and benefits, termination provisions, notice periods, confidentiality and restrictive covenants, and importantly, your indemnity provisions. From a director's perspective, this provides clarity and certainty. It helps avoid disputes about expectations, performance, or on an exit. And without a clear service agreement, directors may find themselves exposed to unclear entitlement to notice or compensation and disputes over post-termination restrictions. A well-drafted service agreement helps ensure that directors are treated fairly, that the termination processes are clear, and risks are managed on both sides. So this is extremely important where directors are also employees or shareholder directors. So to summarise, directors' duties carry real personal risk. Director insurance and service agreements don't remove the risk, but they help manage it. And D&O insurance provides financial protection against the cost of claims, and together they're considered fundamental tools for anyone acting as a director. Next slide. So there is a continued focus on ESG across the corporate governance front. ESG stands for environmental, social, and governance. It's a framework used to evaluate the sustainability and ethical impact of a company's activities. And there's been a continued focus on ESG in recent years that doesn't seem to be going away anywhere. So environmental focuses on how a company impacts the natural environment. For example, your carbon emissions, energy use, waste management, water usage, and climate change risk. And for directors, managing environmental risks protects the company from fines, reputational damage, and long-term operational disruption. Social covers relationships with people and communities. For example, employee health and safety, diversity and inclusion, human rights and community engagement. And for directors, strong social practices improve employee retention, brand reputation, and stakeholder trust. Governance then relates to how the company is run and controlled. For example, board composition, executive pay, anti-corruption policies, risk management, and internal controls. And for directors, good governance ensures compliance, ethical decision-making, and reduces legal or regulatory risk. ESG reporting isn't just paperwork, it's a tool to demonstrate compliance, show responsible governance, manage risk, and communicate the company's long-term strategy and sustainability performance to stakeholders. Next slide, please. So before we finish today, I'm going to spend a few minutes on some recent and ongoing regulatory changes that directors should be aware of. So over the last couple of years, there's been a significant shift in the role of Companies House and related regulators. Historically, Companies House was largely a passive register. That is no longer the case. The direction of travel is clear: greater scrutiny, greater transparency, and greater personal responsibility for directors. Many of these changes arise from the Economic Crime and Corporate Transparency Act 2023, which is currently being implemented in stages. At high level, the most recent and important thing for directors to understand is that Companies House is no longer simply accepting information at face value. It now has enhanced powers to query filings, reject information that appears not just inaccurate anymore, but inconsistent, and shares information with law enforcement and other regulators. So for directors, that means that filings are no longer a tick box exercise, and accuracy, consistency, and timeliness matter now more than ever. One of the most significant changes being introduced is the mandatory identity verification. So directors and persons with significant control, your PSCs, will be required to verify their identity with Companies House. And the aim is to prevent the misuse of companies for fraud and economic crime and to promote transparency. In practice, this means that new directors will need to verify their identity before or shortly after becoming a director of Companies House, and existing directors must now complete their verification. You'll see from your own company's individual Companies House page what date you have to have your ID verified by, and these dates are all different because the requirements are being phased in over 12 months beginning in November 2025. Directors can verify their ID themselves by using the service available in Companies House, or you can go to an authorised corporate service provider to verify your identity. Milselig is an authorised corporate service provider and can provide that service for you. The verification process will involve either you popping into your office or having a Teams or Zoom call, providing photographic ID and an approved document that verifies your residential address, and we'll then verify that with you. Milselig then complete the registration in Companies House, and you'll be provided with a unique director verification code. This code is emailed out to you directly from Companies House, and you have to keep this extremely safe because you'll need to input that code when completing various filings in Companies House in future, like your confirmation statements or director appointments. At the moment, it's causing a bit of hassle because you're not able to file your next confirmation statement in Companies House without verifying your ID, and delays in filing your confirmation statement can lead to companies being struck off the register, so it's important that your ID is verified as soon as possible. It's also worth mentioning that if you're a director of multiple companies, you only need to verify your ID once, and that same code is then input into the various different companies that you're a director of. So for directors, the key message is simple: identity verification is becoming a part of the compliance baseline. Another important change relates to who is allowed to file a Companies House. Going forward, filings will increasingly need to be made by either the verified director themselves or an authorised and regulated agent, also known as an authorised corporate service provider, which Milselig are registered as and can help you with those filings. This affects your accountants, company secretaries, and other agents who file on a company's behalf and making sure that they're properly registered. So directors should now ensure that anyone filing for the company is properly authorised and internal processes are up to date to reflect these new requirements. There have also been changes to how your statutory registers are to be maintained, so that's your company books. Some registers that were historically kept by the company, such as your register of directors and your register of PSCs, are now going to be maintained centrally at Companies House, so you don't technically need to keep those in paper form anymore. Other records, particularly the register of members, register of allotments, and register of transfers, still need to be kept by the company itself, either in paper or electronic format. And directors should ensure that internal record keeping procedures have been reviewed. Information held internally aligns with what appears on the public register, because inconsistencies between internal records and Companies House filings are now more likely to be flagged. And because of that, we would just advise that the internal records continue to be updated and maintained as normal to avoid any inconsistencies. Alongside these changes, the consequences for non-compliance are also becoming more serious. So persistent failures to file accurate information or meet verification requirements may attract civil penalties, lead to criminal offences, and increase the risk of director qualification. And these are not theoretical risks. The intention behind the reforms is to make the UK corporate register more reliable, and that inevitably places more responsibility on the directors. So what should directors be doing in response? First, make sure that you understand and complete any identity verification requirements as soon as possible. And second, review who is filing documents for your company and ensure that they are properly authorised. Third, check that internal records align with Companies House filings. And finally, treat Companies House compliance as a board level issue and not just an administrative one. These reforms are not about paperwork, but they are about accountability and transparency. So to conclude, Companies House is becoming a more active and assertive regulator, and the compliance burden on directors is increasing. But directors who understand the changes and put good processes in place, like your articles, shareholders agreements, service agreements, D&O insurance, and take advice where needed, can manage these risks effectively. As with much of what we've discussed today, awareness and early action are the key to protection. And that wraps it up from Lindsay and I on directors' duties today.
Emma and Lindsay, thank you so much for that. Who thought being a business owner director was an easy thing? It really is a minefield for everybody, and people think that it's easy to run a business. I think if you just listen through to that list of responsibilities and the jeopardy that's potentially involved for people, I think most people would begin to understand uh, just how tricky it is to run a business. So your session being so clear and so thorough, I think has been incredibly helpful. Excuse me, before I kind of get on to the questions, just kind of pick out a particular line that was used there, which is directors are not expected to know everything, but they are expected to know when to take advice. And I think that's a very useful instant takeaway for everybody. If you didn't capture everything that was said today, even on live or on when you review it or watch back again the recording, I think people should really listen to that one piece of advice to begin with, which is you don't need to know everything, but you definitely need to know when to take advice. And that's the reason why we have partners like Milselig alongside us that can be able to provide people with that advice. I have some questions here for you both, and feel free to choose who answers those questions in the next kind of 10 minutes or so. But uh, obviously, disqualification is the ultimate sanction here for any director that has very significant legal and personal implications for directors. But in your experience in working in this area, what are the kind of behaviours most commonly found that leads to that director disqualification? What are the kind of big mistakes that you see repeated time and time again?
I'll take this one, Emma.
Go ahead.
So I obviously touched on this a little bit during my part, but I think disqualification, it's normally patterns of poor conduct. It is, unless it's for one massive serious breach, it's usually something cumulative. So it'll be the stuff like failing to keep proper records, or not filing your accounts or returns, or failing to take proper advice when you should have. It's that whole silence and inaction piece. So you would normally see it's about an ongoing governance failure, maybe, unless it is one huge, big, serious breach that we're dealing with. But Stephen, just as you said there, it's if you're not sure what you're doing, you're better to ask, I suppose, to avoid any disqualification risk.
Right. Thanks for that, Lindsay. Another question we have here is that when should directors really start thinking about those insolvency duties? So when is a good time to start? If you think that the business is going wrong, things are going badly, when do you really need to start thinking about this stuff and potentially taking that kind of trusted third party advice?
I think it's probably, you would hope that you're taking financial advice throughout when you're running your company, that you're constantly in touch with any financial advisors and stuff that you have, or that you do have a finance director on the board who's keeping a close eye on these things. But as soon as the company's really struggling to pay its debts, and you're getting under that cash flow, and will we have money at the end of the month to pay our staff, and do we pay staff, do we pay that creditor that's been outstanding for 60 days, when these are the questions that you're asking yourself, you need the advice. Essentially, that's when you should be speaking to an insolvency practitioner, working out what your next steps are. As I said, Richard and Catherine will be able to give much better detailed advice on what your next steps and your options would be when you are hitting these questions and these issues. But basically, once these questions start ringing in your head, that's really the time that you should be taking the proactive decision to take advice. And it's when you're switching the hat from benefit to the company as a whole to, we've got a list of outstanding creditors here that we need to start paying. So it's that's the main thing. It's the cash flow, not able to pay debts, worrying about paying staff. Once those issues arise, you're in a state that you should definitely be asking for some advice.
And I think that's a very useful kind of trigger for people to picture that themselves when they go back to their own businesses. Hopefully not too many are in that position, but uh, just asking yourself those simple questions at that moment in time. This is a pattern of behavior within the business, not personally, but a business behavior that really is that trigger for kind of reaching out and taking that advice. And as you say, we have a specific session on insolvency, which actually tells people, or should be able to tell people, about types of actions to take if that's the that's the experience that people are having. Uh, but from today, it's that kind of look out for those kind of triggers, those warnings. This is a call to action to do something in terms of your director's responsibilities. Uh, I mean, all of this is mostly around kind of protecting people, protecting directors, as well as protecting the business. Uh, but from your experience, what are the kind of most effective ways directors can protect themselves if a company does get into difficulty? Where's a good place for people to kind of start?
Well, we kind of touched on that throughout this, Stephen, and that directors can't eliminate the risk, but they can help to manage it. So again, just as Lindsay touched on, take your professional advice whenever you need it. Legal, financial, corporate finance experts, they'll always give you the information that you need and will help you just get you through the tunnel to understand where you're at and how you can protect yourself and hopefully protect the company as well. Always documenting the process. So what advice you've received, what alternatives you've considered, and the reasons behind you've made the decision will also offer protection if your decisions are ever scrutinized down the line. We talked a bit about directors and officers insurance, which is a big one. So it can protect against the cost of defending certain claims that are brought against directors. So if D&O insurance isn't something that you maybe don't have in place at the minute, it might be worth sitting down with the board and talking about it and reaching out to insurance providers to get quotes or to see what they look like, to see if they suit your type of business. And then it's just following your service agreements and your articles closely. So I mentioned at the beginning, it's important that directors know these documents and know what they include and what that looks like in practice. So it's not just something that's put in the top drawer and you don't have to think about it again. It's good that these documents are written for you and for your company. So they're to be regarded in the decisions that you make daily. And in that way, they will protect you because you'll be doing it just as was agreed and signed up to. And then just the combination of all of those things, Stephen, goes a long way to reducing the personal risk for directors.
Thanks. I mean, and then when you talked about the changes at Company's
Yeah.
House, and you talked about the anybody who is a director will have had those notifications from Company's House about verifying your identification. The interesting thing for me is that as you were speaking, I went and checked mines.
Mhm.
So I verified my identity, but it's not listed against me as a director in some of the companies I'm involved with. So
Okay.
that even if I got nothing else out of today, it is shit. We'd better do something here to make sure I sort
Yeah.
that out.
So often we have seen that pop up, Stephen, and sometimes that pops up where Company's House isn't the best at matching up details. So maybe where on one company you might have a middle name listed and in another company that middle name isn't included in your director name, or maybe perhaps your residential address or something is different. Company's House won't match those up. And then it's just going through, and whenever you're filing your confirmation statement, you'll not be able to do it unless you put in that director's identity code. So yeah, it's just making a wee note to log in and get your authentication codes and your director verification codes, log in and get them filed whenever it's at the forefront of your mind.
Yeah, so it's clear. I mean, I've had to gather these up for the directors of manufacturing Northern Ireland. Challenging that was a challenging exercise for some of those people who are some in large organizations, and they have people who are holding these codes in certain locations, et cetera, et cetera, et cetera. So I mean, I think if that experience tells us anything, it is Company's House is changing. There is a big change in terms of their role, in terms of not just verifying people's identity, but actually going in and not just passively receiving documents and hoping for the best.
Yeah.
But they will be auditing, for want of a phrase. So people need to kind of take in mind that process of verification is one very visible step towards the changes that are happening in Company's House and the responsibilities that come with that for directors.
Mm-hmm.
Emma, you also talked about ESG and for many organizations that was something that they felt that they had to do because their customers were asking for it, or maybe
Yep.
their consumers were asking for it. But it's moved into a much more important space for businesses where these are now responsibilities and not just marketing tools. Uh, I mean, for boards, what are the kind of simple approaches around ESG in terms of routine governance that people really should be including as part of their compliance?
Yeah. So I think it's important to just break down what ESG is, and it shouldn't be something that's a big, scary, separate one-off item on the agenda. You could create different committees or assign one director in particular to look at the ESG risks or the different ESG opportunities that might be available to your company. But you can set clear and measurable targets and then review them periodically. So it can be small things. So I touched on energy efficiency. So that's something as simple as switching out your light bulbs for something that's just more energy efficient and it's going to save you money down the line as well. You can look at your waste recycling. Are you recycling? If you are recycling, are you doing it properly? Health and safety. Have you got your proper policies in place? Are employees aware of them? Do they understand them? And then your community engagement. Just what could you be doing more with your community? And when you break it down like that, ESG isn't this big, intimidating, overarching thing that people have to all of a sudden be compliant with everything. When you break it down to a kind of manageable daily level, you kind of realize that most companies will be meeting ESG targets and complying with ESG just in what they do daily. But if you sit down and just make out even like SOPs or various targets about what you want to reach for ESG and then just work through them. So it's just about making something that's actually able to be achieved. And then whenever you achieve those, you can move on to something bigger and better. So it's just about, I think people try or it can get overcomplicated when they do look at it as this big overarching thing. But when you break it down, a lot of companies are they're pushing towards ESG every day and they maybe just don't realize it.
Thank you. And just in terms of one final question before we close,
Mhm.
how can directors protect themselves personally while still taking those strategic risks for the company? Entrepreneurs, business leaders, they, I'm not saying that they live on the edge, but they have they need to have a risk tolerance that allows them to invest, to push forward, to take decisions uh, that others won't take because there's either an opportunity or there's a challenge that needs to be overcome. So how can the directors kind of protect themselves whilst at the same time maintaining that tolerance towards risk that is required in order to grow a business?
That's important to with that in mind, it's important that a board understands where it's going, Stephen. So a board and a company need to understand where they're heading and what the strategic risks are and getting there. And whenever you have those sussed out, not all risks are going to be obvious to you, because if that was the case, then nobody would be doing anything wrong or going wrong in any way. But if a company and a board of directors is aware of where they're going and what they have to do to get there, then they can put proper frameworks in place. So like your shareholders agreement, your director service agreements, your articles. And within that, then the directors will have clear frameworks of what they can do and what they can't do, the risks that they're able to make and take, and the risks that they can't actually do because they maybe have to go to shareholders to get approval to move that bit forward. So whenever you have those types of frameworks in place, it allows directors to still take risks, but they're taking risks within a framework where they know I'm not really going to act out here because I'm still operating within my own framework and within what my role is required to do. And then again, just your director and officer insurance is a big one there, Stephen. So that'll still protect directors if they are making risky decisions and things like that, that if something does happen, then they'll have their insurance in place that they can fall back on.
Lindsay and
I just,
Emma, our
I
time
was
is
just
up.
sorry.
Sorry,
Oh,
go ahead,
sorry.
Lindsay.
I was just going to add to that too, just to say that that question probably really ties in the whole theme around governance and around all the duties and showing, having to show your reasonable due care, skill, diligence. Um, and one of the big things with governance is documenting your decisions. If the directors can show that they took that they took everything into consideration that they should have, that they were really transparent with all our board members, that they were transparent to its shareholders, then showing that they tried to do everything the right way might not always work out to be the right decision for the company. But if it shows that they were like reasonable and they were aiming to act responsibly, then that goes a long way towards protecting them, because it shows that they at least had their duties and stuff in mind when trying to run that more entrepreneurial side of them with the risk factors and stuff to try to grow a business. But just it's the good governance, the minutes, the showing your decision making and all that sort of stuff.
Yeah, I think that's really helpful advice, in that you can still make entrepreneurial decisions and calls. Uh, but to document your intent was legal and good intent, rather than ignoring what are very deep and potentially illegal challenges. So I think if people do kind of take two things away from today, one is document your intent, show that you were intent on doing the right thing and trying to ensure right decisions were taken. And secondly, you don't need to know everything, but you do need to know when to call in the cavalry and the support that's required in order to protect all parties involved. Lindsay and Emma, really thank you so much for your time. It was really detailed and but digestible, which isn't an easy thing to do with law. Uh, and it's the reason why I never did law. Uh, so thank you for making that something that was helpful and easily consumed by the audience. Do obviously in the theme of when to reach out and not needing to know everything, but needing to know when to take advice. The contact details for Lindsay and Emma are on the screen. If people want to contact us directly, we can put them in contact directly with Selig as well. But it was a really important session. And if people have very specific legal inquiries, then please do reach out to the practice and to Lindsay and Emma if you can. We will be sharing a recording. We will be sharing the slides. So we'll get that out to everybody in the next couple of days. Our next session alongside Selig is on restructuring and insolvency and how to protect your business, as Emma and Lindsay explained earlier. That's taking place on the 4th of March. Please do look out for that. Please do register for that. But in the meantime, Lindsay, Emma, thank you so much again, and we'll see you all again in the future. Thank you.